Welcome everybody to our Summer HRLaw webinar. I'm Jo Chatterton, head of the employment team at Fox Williams, and it's great to have so many of you with us this morning. I'm sure that many of you will be focused on how you will manage your new normal following the announcement yesterday that from later this month, the work from home if you can guidance is going to be lifted. So this session is going to help you identify some of the tricky areas you need to consider as you develop your plans for the so-called new normal for your business. And we've set out those areas on the next slide. So I'm delighted this morning to introduce you to Kerry Kirby, who recently joined us as the employment team's professional support lawyer. Now, Kerry is also Fox Williams' first entirely virtual team member because she lives in Scotland, where she's speaking to us this morning. So she is very much part of our new normal at Fox Williams. I'm also joined by Imogen Jane, who has stepped in at the last minute for Daisy Jones, who unfortunately can't be with us. So this is her first HR Law webinar. I'm sure you'll be hearing more from both Imogen and from Kerry in the future. Now, there's quite a lot to get through this morning. If you do have questions, if you could pop them into the chat function, then we can address as many of those as possible at the end of the session, but we will try to finish as near to 10 o'clock as possible. But before we start, we thought we would have a little poll to just see some of the questions, have some questions about some of the issues that we're going to talk about this morning, just to take the temperature in the room and to see so that we can all see what others are doing. So if you'd like to take a moment to do the poll, which should have appeared on your screen now, and just click the answers. We'll give you about 30 seconds. It shouldn't take too long to do, and it'd be interesting to see the results. So hopefully most of you have had a chance to do that. If we give another 10 seconds or so, then we will pop up the results and we can see what people's responses were. Okay, Jess, you're in control of the poll. Do you want to pop up the results? Great, so we can see that most people actually not looking to reduce their office space, but it looks like an even spread around people having more flexible working requests. People not using monitoring software on laptops, which is interesting, and Kerry's going to be talking about those issues relating to that. And good news for many of your workforces then, very few of you contemplating redundancies, and also very few of you asking about some holiday destinations. So we'll pick up on some of those issues as we go through. So Jess, if I could have the next slide, please. Because we're going to start this morning with looking at hybrid working. Now, one of the lasting legacies of the pandemic is, of course, the changing landscape in relation to flexible working. And the government has recently announced that it plans to commence a consultation over the summer to seek views on whether flexible working from home should in fact become the default option, unless there are good reasons not to. And contrast that, of course, with the current statutory regime, where a formal request comes in from an employee with 26 weeks service, and it can be confirmed or rejected for a number of business reasons after a prescribed process has been followed. Now, what we found is that most of our clients across a variety of sectors, in fact, are leaning towards a hybrid working policies with perhaps a minimum number of days in the office each week, but with some flexibility over the particular days. Now, the working arrangements that will best suit your business, of course, will depend on lots of different factors. It might vary from employee to employee, depending on their seniority, the level of supervision required, perhaps whether you're in a regulated sector, whether you can ensure that you have good business continuity with home workers, and any knock-on effect on client service. I think one of the messages also that comes across very strongly from our clients is that many are concerned to preserve their positive culture. What you're going to need to consider are the employee relations issues in terms of implementing any working arrangements. A key consideration in that is whether to adopt a more principle-based agile working policy rather than setting down a prescriptive set of working rules for employees. I think there are benefits and drawbacks to both approaches. Principles obviously offer quite a lot of flexibility. So as your new policies bed down over the remainder of this year and into next, they can be adapted to cover perhaps unforeseen issues that may arise. For example, a drop in productivity. And further detail can be added to the rules over time. Many employees will likely appreciate the ability to control their working weeks while also working, of course, within the parameters of business expectations. But in contrast to that, prescriptive rules may be harder to adapt and perhaps give employees scope to argue that the rules create actual or implied contractual rights. But the rules offer business certainty and also certainty to employees and perhaps enhanced accountability. And some businesses, I think, may consider that that's a trade-off that is worth making. Our general recommendation is caution in relation to implementing hard and fast rules which can't be changed, because flexibility, I think, is really key here, because it is difficult to foresee how effectively new working arrangements will be in practice and the challenges that they will throw up. Agile working principles, which are regularly reviewed and updated, I think offer more scope to change than fixed rules. Could I have the next slide, please, Jess? So how do you minimise the risk and maximise the reward from a hybrid working model? Well, it'll be really important to keep a close eye on any undesirable consequences of hybrid working, such as the risk of a two-tier workforce or perhaps particular groups of employees who are disadvantaged, such as female workers, and potentially exposing the bank to indirect discrimination claims. And impact assessments will play an important role in assessing your chosen agile working policy and how effectively it will be in practice. So these should really be carried out regularly. Do you make sure that your workforce understands the rationale behind your new working arrangements before these are implemented, ideally? Factors such as team collaboration, risk management, supervision and monitoring, and any regulatory requirements are all relevant considerations that can be documented and fully explained to staff to justify your decisions. Where possible, it's helpful to consult employees, again, before proposals are finalised, and build then any appropriate general suggestions or feedback into the new arrangements. Individual employee concerns, though, should be dealt with on a personal level, and obviously grievances should be addressed through the normal channels using your internal grievance policies. I think one of the key things is that managers should be trained on any new policies and protocols, and that's because you want to ensure not just that they understand what they are and can implement best practice, but also that they do so consistently across the business. Because being inconsistent brings with it the risk of claims for differential treatment. And of course, that could include discrimination or constructive dismissal claims, or just poor employee relations more generally. Could I have a next slide, please, Jess? So I just want to touch on a couple of tricky issues that you may face with a sort of change to your working model. And the first of those is reluctant returners. Now, there may, of course, be a variety of reasons why some employees are reluctant to return to the office or to commit to a new hybrid working arrangement. And we generally recommend a cautious approach with reluctant returners. It may be that their contract can require them to work in the office, and it could be considered a reasonable instruction to ask them to do that. But the impact of COVID on their personal circumstances, I think, should not be underestimated. And we think that tribunals generally are likely to adopt a fairly sympathetic approach for some time to come. Although it's not a given, of course, that COVID-related claims will be successful, particularly if you followed all of the appropriate health and safety requirements and your workplace is kind of COVID secure for the return to the office. So an example of one of the cases that's coming through now from the employment tribunals is the case of Akitatis and Fortuna Group. And in that case, the employee, who was a sales and project marketing coordinator for a firm that distributed PPE, failed in his claim for automatic unfair dismissal in circumstances where the employer had required him to attend the workplace rather than agreeing to his repeated request to be placed on furlough. Now, the employment tribunal accepted that the COVID threat gave rise to circumstances of danger, which the employee reasonably believed to be serious and indeed imminent, but it held that his demand to be furloughed wasn't an appropriate step to protect him from danger. It said that it was clear the company had never been busier, they had taken steps to make the workplace COVID secure, and the individual's job could not be done from home. Now, this is obviously a helpful first instance decision, but it's always worth keeping in mind, of course, that these cases are inherently fact specific, and in different tribunals, different views may be taken. Could I have the, oh, sorry, not the next slide yet. So the next point is always to consult with your reluctant returners directly to understand their concerns, and also work out if steps can be taken to alleviate those concerns. It may well be that there's relatively small adjustments, such as allowing them to work in less busy areas of the office, or perhaps adjusting working hours to prevent travelling to work on the tube or in rush hour will be enough. Remember, of course, that with an employee who has a disability, you would, of course, need to consider document and implement reasonable adjustments in accordance with the requirements of the Equality Act. Now, as a very last resort, really once you've explored all options, it may be possible to require a reluctant returner to revert to office working, and you could use the disciplinary procedures if necessary. But if that does become relevant, there are likely to be risks around constructive unfair dismissal or health and safety detriment claims, and possibly discrimination issues to consider. So it's always advisable to take some advice about the most appropriate course for your business, balancing the desired outcomes with the risks. I could have the next slide, please, Jess. So the other issue, tricky issue I want to touch on is updating your employment contracts. Now, if you're planning to tailor employment contracts to cover new working arrangements, obviously the first step is to identify which clauses are affected and which variations are required to meet your future needs. If you have an existing mobility clause which permits flexibility over the location of the workplace, then it may well be that wholesale changes aren't actually necessary to implement a new agile working policy. But remember, of course, that amendments to employment contracts should still be implemented with specific employee consent where possible. And the best way to achieve that is by providing sufficient information about the proposed amendments to allow consultation with employees in relation to the impact on them and on the business as a whole. Now, the other advantage, I think, of the consultation process is that it does help you to identify any resistors, and also to explore the risks, such as breach of contract claims, discrimination, constructive unfair dismissal, that are associated with unilaterally imposing any changes. Now, as a very last resort, you may consider dismissal and re-engagement if consent is not forthcoming. Now, it may be that you only use the contractual ability sparingly, and once you've considered all of the risks in relation to the individual, but we think it remains good advice to have a contractual power to require an employee to attend the office if you do update contracts to provide for employee flexibility. Now, one thing you do need to bear in mind is the potential to engage collective consultation obligations under the Trade Union and Labour Relations Act of 1992. I've summarised those on the slide, but broadly, these may be triggered if there's a proposal to dismiss employees on their current contracts and then to offer them re-engagement on your new updated contracts. And there are at least 20 of those employees at one establishment, and that process takes place within 90 days. And that's the case even if no redundancies are contemplated, because the definition of redundancy for these purposes is a dismissal not related to the individual concerned. Now, as you'll be aware, information and consultation timetable is prescriptive, and you face a potential hefty tribunal award for any breach. That's 90 days pay for each affected employee that you haven't informed and consulted. You've also got to submit a form HR1, and if you don't do that, there is a criminal sanction attached for a failure to do so. So if you do foresee that you might need to dismiss and re-engage people on new contracts, if they don't agree to sign them, then we'd be very happy to assist to ensure that you stay on the right side of your legal obligations. So that's all from me for now. I'll be back shortly, but I'm going to hand over to Kerry, who's going to talk about monitoring the remote workforce.
Good morning, everyone, and thank you, Joe, for that warm welcome. I'm delighted to be the new member of the Fox Williams team, and I hope to work alongside some of you in the future. So today I'm going to speak to you about monitoring the remote workforce. Jess, could you pop the next slide on, please? So there are many positives to home working, but one of the consequences for employers can be a concern about standards slipping the longer it goes on. And employee monitoring is one of the solutions for addressing those concerns. However, a recent YouGov and SkillsCast survey found that 59% of the 2,000 employees surveyed wouldn't work for an employer that tried to use remote monitoring software to track their work at home. Quite an interesting statistic. But what do I mean when I talk about monitoring? Well, the options are varied and include content monitoring, so emails or other electronic comms, specific checks on individuals or group activity, and spot checks as well, so relating to the activity itself, such as website traffic or email volumes, rather than in relation to particular individual employees. You might be thinking, well, monitoring's nothing new. It's been an issue for some time now, but pre-COVID, the emphasis with employee surveillance tended to be towards ensuring internal compliance. And since the start of the pandemic, it's clear that there's been an enhanced focus on productivity and performance monitoring instead. And we foresee this continuing as working from home arrangements settle into agreed long-term patterns. Concerns about efficiency and loss of supervisory control are quite common in relation to home workers. And obviously from a performance perspective, managers can't review their remote team unless they've got supporting performance evidence available to them. As a result, sophisticated methods of digital monitoring are becoming more common, and these often equate to stamping the digital time card. So for example, recording when an employee logs on, opens their work-related apps, engages with Teams or other video conferencing. And all of these can reveal a pattern of working hours. They can identify if an employee is doing what's expected of them, or from a welfare perspective, it can allow you to think about if any untoward or excessively long hours are being worked. There's also facial recognition software that can monitor time spent at the laptop, and PwC employees are no stranger to this because last year the organisation introduced it to log screen absence for home workers. And they faced quite a lot of criticism in the press, but argued at the time that it helped them meet their compliance obligations as workers would normally be monitored on the trading floor. And indeed, the FCA has declared that it expects rigorous oversight of financial industry employees who are working from home. There's also the ability to take desktop screenshots, record computer mouse movements or keystrokes, which would reveal the full content of communications in real time. I think 97% of you that answered our poll at the beginning suggested that you're not already using this type of software, but it may be something obviously that is in the pipeline or something that you're interested in finding out more about. Well, it can be downloaded remotely onto home worker laptops, or alternatively, it can be installed in advance on equipment for new joiners. And health and safety obligations are another consideration. So while we remain under the work from home guidance for another couple of weeks, 19th of July, and possibly beyond that date, really, you're likely to keep quite a close eye on when employees are accessing the office and on which days, so that you can control both the numbers and make sure that you're complying with the health and safety duty that you owe to staff and visitors. And to keep the office COVID secure in this way, some employers might enhance their monitoring in relation to security passes or facial recognition software. There can be cameras in common areas, or in some cases, equipment tracking software. But we do, as ever, recommend caution and bespoke advice if you're thinking about these enhanced monitoring methods, because the legal issues are often far from straightforward. Could I have the next slide, please, Jess? Which leads me to the legal background and the importance of ensuring that your monitoring will be legally compliant. So what does the law say and how has it changed? Well, literally nothing's changed in light of the pandemic itself, and the law does remain as it has been for some time. A summary of the various legal considerations is set out for you on the slide, but the starting point is unsurprisingly UK GDPR and the DPA 2018. These are engaged whenever you're processing employee personal data, and you must have a legal basis on which to do so. Unfortunately, employee consent is not going to pass this test because it's not considered to be freely given in the employment relationship due to the imbalance of power. So the legal basis which is most likely to be relevant to your monitoring is that of the legitimate interests of the employer. That means you should ideally carry out a legitimate interests assessment, which will allow you to assess and document the process you've followed to identify your legitimate interests and the justification behind that. Examples could be preventing the misuse of company systems, protecting data, ensuring compliance with internal policies and regulatory requirements, or even to monitor generally the performance at work. A data protection impact assessment should also be undertaken, as most employee monitoring activities are recognised as posing quite a high risk to employees' rights and freedoms. And both of these steps will help you assess what you're trying to achieve or guard against, and whether the methods that you've chosen will amount to a proportionate means of achieving those aims. The Employment Practices Code from the ICO also offers helpful guidance for employers. As things stand, it's currently being reviewed, which is pretty urgent because it hasn't even been updated to reflect the DPA 2018, and nor does it particularly reflect the massive tech advances that have happened in the last 10 years. There's also supplementary guidance, and that covers both systematic and occasional monitoring. The ICO accept that some employee monitoring is par for the course in the employment relationship, but the overarching message is that on almost every case, a data protection impact assessment will be required. The Investigatory Powers Act 2016 is also relevant, and as are the subsequent monitoring and record-keeping 2018 regulations. However, the important point to note in that regard is that these apply in relation to interception, so monitoring emails as they're being sent out in real time, rather than the standard employer practice of monitoring sent emails that are within your own IT systems. The European Convention on Human Rights, Article 8, right to privacy and family life is also of relevance, although there is no standalone legal right to privacy in the UK workplace. That said, the Article 8 right often does feature as an employee argument, because UK courts and tribunals are required to interpret UK law in line with the ECHR. And the argument frequently crops up where an employer has monitored private emails or messages sent on work systems, or looked at personal social media accounts or devices, and the findings have then led to disciplinary action or a dismissal decision. And what the case law tends to demonstrate is that there's a very clear balancing exercise to be conducted, and that's between the individual employee's expectations of privacy, which will generally be lower in a work context, alongside the competing legitimate interests that the employer is seeking to protect. Proportionality is often the linchpin, and while much of the case law does fall in favour of the employer in that regard, it will be interesting to see if it changes as home working cases start to trickle through. Again, at a European level, there's guidance from Article 29 Working Party Opinion from 2017, but it's no longer directly applicable to the UK since Brexit. It just remains a source of useful guidance on GDPR and monitoring. Next slide, please, Jess. So focusing now on the legal risks to the business, well, if the monitoring you carry out is viewed as too excessive or intrusive, then employees may raise a grievance or resign, arguing that the employment relationship has been irreparably damaged. You could therefore face a constructive unfair dismissal claim under the Employment Rights Act as a result. And equally, any decision on your part to dismiss an employee must obviously be for a fair reason and follow a fair process. And that means that monitoring evidence on which you rely to reach a dismissal decision should have been obtained in a legally compliant way. A complaint to a manager or HR that the company's monitoring activities are unjustified and in breach of the UK data protection regime could arguably also amount to a whistleblowing disclosure. There are various hurdles for an employee to get over in that regard, but it can be quite an attractive unfair dismissal claim for those who don't have 2 years service and because of the potential for uncapped damages. A detriment claim is also available more widely to workers if they can show that they've been treated unfavourably for making a protected disclosure. Also, do take care in relation to the groups of employees you choose to monitor. Ideally, don't focus solely on home workers, for example. You might have a higher proportion of employees with protected characteristics who are working from home in the long term. So there could be exposure to discrimination claims as well under the Equality Act 2010. In terms of enforcement, individuals can bring a claim for breach of the GDPR, and don't forget also the management stress that can be inflicted by a data subject access request if they want to gain access to all the personal data that the business holds against them. But the ICO also has the power to investigate complaints and where appropriate can take enforcement action. That carries the risk of reputational damage, but also the chance of a fine of up to 4% of global turnover or £20 million, whichever is greater. I mean, obviously these figures are most likely to be relevant to mass data breaches, but I do think it's still one to be aware of. Could we have the next slide, please? In terms of practical tips for compliant monitoring, broadly, do ensure you're monitoring in a way that's compatible with the law. The workforce needs to have a clear understanding of when their personal data is likely to be obtained, why you're obtaining it, how you'll use it, and to whom it may be disclosed. And so transparency is incredibly important in this regard. The best way to go about that is to keep your employee privacy notices up to date, to reflect the monitoring that you carry out. Because communication is going to be fundamental, it means that employees are fully aware of the curbs on their privacy expectations while they're working from home or in the office. And that can itself go a long way to preventing complaints further down the line. I've already mentioned the importance of legitimate interest assessments and data protection impact assessments, not least because they provide a defensive paper trail in the event that you face any complaints, tribunal claims, or ICO inquiries. If you do introduce new methods of monitoring, please make sure that your existing policies are updated to reflect the implications. Employees who've been with you for some time might view more intrusive monitoring as a negative shift and that demonstrates a lack of trust. Therefore, any new policy needs to fully explain your intentions so that no one is really caught by surprise. And all the steps that I've mentioned so far will help you demonstrate that your employee data processing is fair, transparent, and for justifiable reasons as required by the legislation. But proportionality will also be key. Is there a less intrusive way to achieve the same aim? And if so, why is it not appropriate in these circumstances? Would it be sufficient, for example, to monitor email traffic rather than to access individual messages? And is the use of facial recognition software really necessary? For some highly regulated industries like financial services, then the answer might be yes, but you do really need to show why you've reached that conclusion. And similarly, it's quite important to avoid mission creep. So the data you obtain should only be used for the purposes you've specified and explained in advance, or you could risk falling foul of the law. The next slide, please. Managers also need to be trained on your new policies, taking account of their roles in relation to the processing of data and the implications for getting it wrong. For example, if someone's reviewing performance data to carry out an annual review, then they should be aware not to use that information for any other purpose. And as with all employee personal data that you collect, do ensure that it's stored securely. So the usual methods will help: encryption, password protection, and generally not leaving it on a train. A limited number of people should also have access to the data, so perhaps a few members of HR or appropriate people in the senior management team. It needs to also be retained for no longer than is necessary to the extent that it's still relevant for the purpose for which you collected it. Do bear in mind it's also not just a case of crossing the T's and dotting the I's when it comes to monitoring. It can have a huge impact on the relationship of trust. So don't underestimate the damage to morale that can be caused by what some employees might view as an unnecessary intrusion into their private lives, particularly if the plan is that they'll be working from home on a long-term basis. And speaking of unnecessary intrusion, well, covert surveillance is rarely going to be appropriate. It's only going to be in exceptional circumstances where it's endorsed by senior management, for example, if there's criminal conduct suspected. And it's not even acceptable in the Houses of Parliament, as we've seen over the last fortnight. I think the investigation into the hidden CCTV camera in Matt Hancock's office is ongoing. But it's also a useful reminder. So covert monitoring does come with controversy and tricky legal issues, and perhaps you don't actually want to know what it might reveal. Finally, don't forget that there is still value in the human approach. So regular manager check-ins with home workers using Teams and other video software, perhaps manual time recording rather than wholly automated processes, because the old methods are not necessarily redundant. And if they work well for your organization and they help you to maintain good working relationships, then you may not actually need to take your employee monitoring to the next level after all. So I hope you found that helpful. It was quite a brief run through, but hopefully gave you some useful pointers. And I'll hand over to Imogen now, who's going to navigate pay and bonus reviews for you next year.
Thank you very much, Kerry, and for the warm welcome, Joe. Next slide, please, Jess. When it comes to implementing new agile working policies, we foresee tricky issues arising over the interaction between office-based employees and those working more consistently from home, with the risk of creating a two-tier workforce. While the pandemic has led to many businesses implementing a whole-scale review of their business, how their business operates, we believe now is also the time to fully consider your organisation's connection between office presence and employee rewards. Next, the need to make a conscious effort on the part of managers to ensure equal access to business information and equal division of workflow. Managers need to be aware of their own prejudices and bias towards certain ways of working. For example, just because some managers have worked in a particular way for years and prefer this to continue, things have changed and staff retention and attraction will be at stake if things are not handled well. Simple things like being conscious of the terminology we use can make a difference. For example, virtual working rather than remote working, with its connotations of being distant and removed, or return to the office as opposed to return to work. After all, what else have we all been doing for the last 16 months? Most of us have actually been working quite hard. Particular care should be taken to discourage the formation of office cliques, where employees regularly working from home may be left out of vital conversations or strategic meetings because they're not physically present. It's important to ensure that there is equal access to business information and workflow is divided equally. Home workers should not be allocated less stimulating work just because they're not in the office. Employers could quickly perceive this as a demotion or a detrimental treatment linked to their decision to work from home. The continued use of remote technology, including apps and video conferencing, is critical to the success of embedding new working arrangements over the long term. Use this technology effectively and inclusively to promote your collaboration wherever team members are located. Senior manager training will be crucial to encourage inclusivity of home workers and prevent difficulties becoming entrenched and negatively affecting the culture. Managers should be encouraged to share relevant information and work across their entire team, not just with the visible staff in their office. The normal communication channels, such as a quick chat in the office, will be less relevant. So don't assume employees have all the information at all times at their fingertips. Managers should also be sure to question themselves. Have they actually done enough to include home workers in ongoing projects? As ever, treat employees as individuals when it comes to assessing their performance as a home worker. What are their specific needs? For example, do they require more training? Are they facing any particular problems with the home working under your new policy? Has it negatively affected their performance or productivity? There is no one-size-fits-all approach, and you may see marked improvement if you engage with employees on the ground. Agile working as a permanent development is likely to be new for the majority of employers, particularly in the professional services and financial sectors, so it's going to be a learning process. There may be benefits which have not yet become fully apparent, such as the extent of financial savings on office space. That said, sticking points and drawbacks will also inevitably appear, and you need to be ready to address these and adapt to avoid a two-tier workforce from emerging. Next slide, please, Jess. As we move towards 2022 and agile working becomes the new norm, you will be faced with the HR minefield that is the annual pay and bonus reviews. As a starting point, we recommend the creation of a business-wide remuneration policy for 2022 at an early stage, which takes into account of any new working arrangements that you have consulted on and presented to the workforce. A remuneration policy which treats the workforce holistically rather than differentiating between office and home workers on the basis of location alone is likely to carry less risk. Remuneration decisions based on clear objective guidelines that assess both individual and business performance, for example, remains best practice. Individual circumstances such as particular conduct issues are, however, still relevant. As ever, performance guidelines should have been well communicated to employees and managers alike over the course of the remuneration period, leaving less scope for surprise, although we all know that this doesn't always happen. If you do intend to differentiate, consider how you will treat employees in various scenarios, such as how will you treat those working solely from home compared to those working on a hybrid basis with the majority of their week in the office, compared to those who are no longer based in London or have expressed a desire to move, and also those who are new joiners. If your intention is to differentiate on the basis of location, please ensure that you have clear, documented justification for why the business intends to take that approach. There may be legitimate reasons, such as the removal of London waiting allowances or a genuine change in the type of work performed at home. But the more evidence you have that the business reasons have been properly considered, the better, particularly when it comes to mitigating the risk of any employment claims. It remains the case that you should continue to have clear, neutral criteria for pay review and bonus awards, which instead of focusing on work location or work pattern, should look at the individual or business performance. Be mindful that some managers may have an unconscious and often sometimes an even conscious bias towards those who are more visible to them in the office, not least because those people may be better placed to actually promote what they do to their manager face to face and to manage their brand than those who are working mainly at home. HR will play an important role in challenging the assessment of performance to ensure decisions are robust and can be objectively justified. So look out for any differential treatment between individual employees or comparable teams, which could give rise to employment claim red flags. In particular, employees should not be individually penalised for their own manager's perception of absent home workers. Ideally, managers will be able to apply your pay guidelines objectively to both office-based employees and those at home, allowing individual managers to exercise complete discretion on implementing pay review principles can lead to various legal risks. Think about building in moderators into the pay review and bonus process if you don't already have them, and the role that HR can play in monitoring decisions by analysis of the pay and bonus recommendations and questioning managers if, for example, it appears those more frequently in the office are being rewarded better and why. One area of possible challenge to pay and bonus decisions is that those more present in the office may actually get better opportunities to perform and be rewarded better because they get the plum work. One view is that it's their choice where to work, and if they work more from home, they could do something about this by being more present in the office. But we're not actually convinced that this argument will cut the mustard with the Employment Tribunal, who will expect parity of treatment wherever employees work. Next slide, please, Jess. So how can it go wrong? Firstly, grievances can be brought by employees who are disgruntled by the outcome of the pay and bonus round under your internal, and they can bring these grievances under your internal policy, which, as we all know, can be really time consuming for managers to address. DSARs often go hand in hand with such grievances, with a view to the employee obtaining a paper trail of personal data that would support any potential claim. So, as well as wider data, any internal emails, meeting notes and performance reviews that are formed as part of any remuneration process could all be up for grabs. There's also a risk of unfair dismissal claims if an employee resigns, and claims of constructive unfair dismissal based on breach of the implied duty of mutual trust and confidence when decisions about pay are not fair or based on an objective assessment of performance and contribution. In addition to such claims, would come hand in hand with a claim for unlawful deduction for wages if, for example, you implemented a pay reduction for fully remote employees without obtaining express consent. Next slide, please, Jess. A policy of paying home workers less as a group or awarding them a lower bonus in general may well face challenge further down the line. For example, there could be an indirect discrimination argument on the basis that such a policy disproportionately affects certain protected groups of employees. I'm thinking of female or potentially disabled employees. It's a well-established argument that female employees are more likely to have a caring responsibility, whether for children or elderly relatives, and therefore may be more likely to favour home-based working under your agile policy. Any disadvantage suffered as a result of being a home worker, for example, allocation of inferior work or exclusion for strategic meetings or even social exclusion, could risk a discrimination claim, but none more so than lower pay rise or a lower bonus award. An employer may try to argue that their policy is objectively justifiable, even if you can show a legitimate aim for paying home workers less, for example, reducing overheads, removal of London waiting where there's no commuting. A tribunal would expect robust evidence that your approach was proportionate. So if there is another way of achieving the same cost reduction effect, this would weaken any defence. Finally, an additional claim that is worth flagging is an equal pay claim. But equal pay laws don't always apply, and it's dependent on the nature of the remuneration involved, being a contractual term. However, all technical arguments aside, higher earning employees are likely to be alive to all the potential claims available to them when it comes to pay and bonuses. So it's worth keeping these at the forefront of your mind. I'll now pass back to Jo just to round up.
Thanks very much, Imogen. So I'm going to cover 4 further topics: the end of furlough, foreign holidays, overseas workers, and long COVID issues. So if I could have the next slide, please, Jess. So as you'll know, the coronavirus job retention scheme has been extended until the 30th of September this year, and it's going to continue to pay up to 80% of employees' pay, but the level of government support will now taper down. The government has gone quiet on previously announced job retention bonus and job support scheme, so it's not clear if there's going to be any sort of replacement scheme or alternative scheme that's going to be introduced. So we now need to think about the end of furlough and how we're going to manage that. Now, our assumption is that your employees are very unlikely to agree to an extended period of furlough with no pay once the government support ends. And few contracts contain a contractual right to lay staff off. So we're going to focus today on the alternatives. So where a return is possible, the first thing you need to think about is obviously ensuring a COVID secure workplace. Now, you will all be well aware by now of the ongoing duty of care to protect the health and safety of your employees and to provide a safe place to work and safe equipment to facilitate that work. And that duty sits alongside various statutory obligations. And these taken together entail that banks ensure they provide a COVID secure workplace for employees returning to work at their offices. Now, we recommend that when you prepare for a wider return, you use the latest government guidance for office workers, which you can find on the government's website. And it covers things around who should be at work, social distancing, face coverings, cleaning regimes, protecting clients and visitors, and business travel and meetings. And when I checked this morning, that's not yet been updated to reflect the announcements last night, but we can expect some changes there. But given the rate of infections is still rising, then there are going to be some requirements we expect on what employers do, rather than just moving back to what it was like before the pandemic started. It's going to be hard to criticise you if you follow the guidance as not having taken reasonable steps to protect the health and safety of your employees. So do keep an eye on that guidance, which, as I said, will be regularly updated. Now, risk assessments do need to be kept up to date. And these are really at the heart of an employer's health and safety obligations, and they shouldn't be static. It's important to update your current risk assessments in light of a wider return to the office and any new working patterns, and obviously to address any additional risks that may be identified as soon as you can. Now, we think it's really helpful to start discussions early with employees who are coming out of furlough to allow time for them to make changes, for example, childcare arrangements, and to address any support requirements given, because furloughed employees may understandably have adapted their family arrangements to suit their new freedom. One thing you might want to consider is a return or induction process, because of course there may have been changes during an employee's absence which they may not be aware of. So managers should review and discuss any new company policies, any changes to their roles or new client processes, for example, that may impact on their performance. And it may be that with some training that helps the transition and alleviates any return or anxieties. Also, it's really helpful to just document all the steps taken in this regard, just in case there are complaints further down the road. Of course, it might be helpful to consider whether sort of home working is available to furloughed employees under the agile working policy. That could be temporary or a transition or part of the transition process, or maybe a more permanent arrangement. And again, do treat the workforce consistently. I think it's a message we've been sort of saying throughout this, but that will be the way to avoid disgruntled and unhappy colleagues. Now, we are already seeing an increase in flexible working applications in advance of the business announcing its return to work plans and announcing where it sits vis-a-vis agile or hybrid working. So while employers are engrossed in new working arrangements and working out what these are going to be for the entire business, it can be quite easy to overlook individual working requests and that they fall through the net, or they continually get pushed back pending new policy rollouts. So it will be important to stay on top of these. The law currently remains as it was pre-COVID, and all current flexible working requests should be managed appropriately and dealt with individually under the statutory regime. Now, there may be some alternatives that you can consider to avoid redundancies. All of them have sort of associated legal issues. So you may consider, for example, changing terms and conditions such as reducing salary and benefits or reducing working hours. And as with any contractual change, you're going to need consent for those. Other changes might be ongoing recruitment freezes, redeployment, temporary sabbaticals, or client secondments, where those might be available. And there will be various legal issues to consider for each, but they are potentially useful options where they're relevant to your business. But it may be that you're not going to be able to avoid redundancies, although it looked from the feedback we had to the questions that actually that's going to affect very few of them, which is a good sign. But if you are in that small group of people who may need to make people redundant, then don't forget that you can start a redundancy process while your employees remain on furlough. There may, of course, be some pushback with employees arguing that that's unfair where the furlough scheme is available as an alternative. But that's an untested argument in the employment tribunal. And it's very clear that the government hasn't said that furloughed employees can't be made redundant. Now, employees cannot claim furlough in respect of any period that they are serving statutory or contractual notice. Now, where employees are entitled to statutory notice and statutory redundancy pay, it should normally be calculated in accordance with normal pre-furlough wages. But there are some quirks in the legislation where, for example, contractual notice pay is at least 1 week more than the statutory. So it may, in those cases, be possible to pay less. So if you're in that position, it's worth taking advice just to make sure you're doing the right thing. Now, of course, all the usual fair redundancy requirements apply. So you've got to go through a fair process. And of course, you've just got to watch the collective consultation requirements, which we mentioned earlier, if your numbers reach 20 or more within a 90-day period. Could I have the next slide, please, Jess? So understandably, many employees, including I'm sure everybody listening in today and those of us presenting, are going to be desperate to have our annual foreign holiday this year and determined to follow through on their plans. But where does that leave you in terms of office risk for returning employees? Now, we recently published a brief summary of the government's current traffic light rules for foreign holiday destinations on our HRLaw update, and it will be available on our website if you've not received that. But it's always best to ensure you stay up to date on the current rules, which are published on the government website. And you can sign up there for email alerts as countries are added or removed to the list. Now, importantly, all of the rules apply whether or not employees have been vaccinated. So one question that's come up, and it from the survey, it seems that people aren't asking the question, but our view is that you can ask employees to notify you of their foreign travel plans in advance of or on their return from holiday, because this allows you to establish which traffic light applies to the employee's destination country and whether they're going to need to quarantine in a hotel or at home on their return. And this way, we think, will be considered a reasonable employer request in light of, the third wave of a virus in the UK and your ongoing health and safety obligations. But the response to your question is, of course, likely to be personal data for data protection purposes. So you will need a lawful basis under the GDPR and Data Protection Act for obtaining and storing that information. And provided your approach to collecting information about holiday destinations is transparent and proportionate, it's likely to be hard for an employee to argue that there's no lawful basis for you to collect and process that information. It's primarily justified for the purpose of complying with health and safety obligations towards your staff and visitors. On the other hand, of course, it's much more difficult to ask employees to provide their post-travel PCR test results because the requirement to quarantine or self-isolate at home is in place, meaning there's little benefit to gathering those test results and keeping that data. Don't forget as well that there is a duty on employers to ensure that they do not knowingly allow employees to attend the office where they should be self-isolating in a designated place. And a breach of those rules could leave you on the hook for a fine starting at £1,000 if one of your holiday returners attends the workplace during the required isolation or quarantine period. Could I have the next slide, please? So overseas workers and the sort of idea of working from home has kind of really been stretched because people have been working in all sorts of different locations during the lockdown. But the location of an employee to a different jurisdiction does have important implications, both practical, for example, time zone difficulties, and legal. It's probably a webinar in its own right, so I just want to flag 6 key points to keep on your radar. We have written about these things in a bit more detail in HR Law alerts. So if you haven't received those, you can have a look at our website and you can find the previous editions. So the first thing is around contractual issues. So if you discover an employee is abroad without consent, they could be in breach of contract, but mobility clauses do mean the situation is far from clear. A widespread informal practice of allowing working from abroad also gives rise to an ingrained contractual right, which may be hard to change without facing potential employment claims. Extended periods of time working away from the UK office can mean employees become subject to tax and social security contributions in the country in which they're based. And also keep an eye on the risk that the tax authorities may consider if you've created a permanent establishment overseas, depending on the particular facts, if you have employees working in different countries. Don't forget also that if employees may become entitled to rights under local employment laws of their chosen country. And these, of course, could be different to the UK rules, providing sort of additional rights, for example, to holiday, severance or redundancy payments, and in some cases, even industry-wide collective and consultation agreements. One thing to make sure is that you have the right insurance in place to cover your overseas workers. I think cover that's limited to overseas business trips probably isn't going to be sufficient. Health and safety obligations apply even though you have employees working overseas. So do take all reasonable steps to ensure that you're on top of this, and that would include carrying out remote risk assessments and addressing any problems that are identified. And then finally, of course, immigration status. Now, again, you'll find on our website some information from our immigration team about this, but do remind your non-UK national employees that the basis on which they can qualify to return to the UK may have changed since they left, especially if they are an EEA national and therefore kind of used to free movement, which isn't in place any longer. Could I have the next slide, please, Jess? So the last issue to cover is long COVID. Some tips for dealing with ongoing sickness issues. ACAS have produced some helpful guidance for employers, which confirms that the usual sickness, absence and sick pay rules apply when it comes to dealing with long COVID in the workforce. So some of the things that I think you need to consider, firstly, employee engagement and support. There's obviously a lot we don't know yet about the impact of long COVID, but the symptoms can clearly vary quite widely from employee to employee. And the NHS website suggests that most people fully recover within 12 weeks, but they may suffer a combination of symptoms such as fatigue, shortness of breath, concentration problems, insomnia, and depression and anxiety. And some of those may last much longer than the 12 weeks. So what ACAS recommends is continual support, perhaps with agreement with the employee over how and when to make contact, and making sure, of course, that the employee's workload is shared between colleagues, and also continually assessing ways to get them back to work whenever possible. And as with any long-term absence, there's going to come a point at which you want to involve occupational health to enable you to assess the employee's prognosis and likely timescale for a return to work. Now, if adjustments are necessary, like a phased return or adjusted hours, these can be then considered and actioned. Now, your current sickness absence policies will still apply into long COVID, but following capability procedures won't be without risk. For example, potential unfair dismissal claims if you were to dismiss an employee on the basis of their persistent or prolonged absence, or of course, potentially discrimination. So long COVID, for example, has been found, I think, to more severely affect women, younger people and ethnic minorities, for example. And that leads, of course, neatly onto the question of whether long COVID is in fact a disability. And you may have seen last week that the TUC was calling for it to be called such. Now, the legal definition for the purposes of the Equality Act hasn't changed. So it's a physical or mental impairment which has a substantial and long-term adverse effect on an employee's ability to carry out normal day-to-day activities. And in every case, it's going to be fact specific. You have to consider the particular employee's symptoms and whether their effect has lasted or whether it's likely to last for longer than 12 months. And remember too, of course, that it may be quite a complex picture because the effects of long COVID could cause or maybe exacerbate other underlying medical problems such as asthma or diabetes. It's ultimately a question for a tribunal to decide, and I think it's generally best to err on the side of caution and accept that there is a risk that an employee with prolonged symptoms could be considered to have a disability for Equalities Act purposes, and then to focus on potential reasonable adjustments and employee support. And just finally, it's worth considering your insurance policies and your income protection policies, and speaking perhaps to your insurance company to determine if employees might be covered under the relevant definitions in the event of long-term absence as a result of long COVID. Now that's all I've got to say. That leaves us with a few minutes to answer any questions. Now I can't see any questions in the chat, so if you have a burning question, please do pop it in there now, and we will answer. We'll try to answer those questions in the time available. And while you're thinking whether you have any questions, you can have a look in the chat box, and we've mentioned several places about the updates that we've been providing through HRLaw and which are available on our website. And Jess has posted the link there so that if you or any of your colleagues want to sign up to HRLaw, then please do so. We will be continuing to address the issues that have been spoken about in this morning, and it's all free, so the more the merrier. So please do sign up if you'd like to. Now, still no questions, so I'm going to assume that we've blinded you, or you've got so much to think about that you've got to go back now and start working on your planning. So, oh no, we've got one question just popped up. Do Fox Williams use monitoring software? No, Fox Williams don't use monitoring software. So we don't have that. I'm not aware that that is in contemplation at the moment. But if no other questions, we will wrap up there. Thank you all for your time this morning. If you do have any questions that arise afterwards, please do let any of us know, or your usual Fox Williams contact. And we hopefully look forward to welcoming you at future events. And finally, just to say thank you to Jess for doing the slides and making sure the poll worked, etc. So thank you very much, Jess, and goodbye, everybody.